Hi, y'all, and welcome to tonight's live stream. Will Chad Daybell's trial be just like Lori's? Same evidence, same witnesses. Will there be anything different? Several people have asked me in the comments, and tonight I'm going to tell you what I think are going to be some key differences that will make the trials very different. Will the outcome be different? That's a different question, but I do expect the trials to look very different, and I'm going to talk about that tonight. So happy Monday, everybody. I hope that you all had great weekends. And I want to give a special shout out to the first 5 in tonight's chat: Miss Construe, Rochelle Toomey, Christy Grange, Mandy Kirk, and Cognac Hobo. Special welcome to all 5 of you. As we get started, if you would hit the like button, it will really help the video get out to more people. I'd appreciate it. And subscribe. We would love to have you back for more. Now, we did full trial coverage of the Lori Vallow Daybell trial. Lori Vallow Daybell is Chad's wife, so many of you are familiar with the bizarre and horrifying Daybell case. But we've been out of the case for a while. So what I want to do is a quick overview just to remind everybody of the basic facts, and then we're going to get to today's question, which is, will the trials look different? Lori Vallow and Chad Daybell were both members of the Church of Jesus Christ of Latter-day Saints, known as the Mormons, and they met at a religious conference. At the time, Lori was married to a man named Charles Vallow, her 4th husband, and Chad was married to Tammy Daybell. Chad ran a company that published books. Lori was a beautiful woman who had competed in the 2004 Miss Texas beauty pageant. She had 2 children who lived with her. Tylee was 16 when, spoiler alert, she disappeared. JJ was only 7. He was autistic and had special needs. Chad and Tammy had been married for 28 years and they had 5 children. But Chad was swept away by Lori's flirtatious demeanor, her stunning good looks, and she was impressed by Chad's storm. I'll leave it to your imagination what that was their pet name for, but Chad and Lori quickly began a torrid affair. But this was not just an affair because it became contorted by strange religious beliefs. Chad and Lori believed that the end times were coming, and at some point came to believe that the 2 of them had been married in a past life. It appears to have been Chad's suggestion, and that they had been called to marry each other again and to jointly lead the 144,000 who would remain on earth in the final days. So with their importance confirmed by God himself, Chad told Lori that various people around them had become zombies. People were rated as light or dark by various degrees. And we can do a whole video on that, but for now, let's just note that. Coincidentally, people who were in the way of Chad's and Lori's glorious mission were dark. They were zombies. Like, for example, Chad's wife and Lori's husband, Charles Vallow, and both of Lori's children, even the autistic 7-year-old JJ. And Lori's nephew-in-law, Brandon Boudreaux, who was disputing custody with Lori's niece. She was very close to her niece. Also coincidentally turned dark. Now, those who helped Lori and Chad, like Lori's brother, Alex, were light. They were near to glory. So gradually, the so-called dark people began to die. Charles Vallow died first. Alex Cox, the brother of Lori, killed him. He claimed in self-defense. JJ and Tylee disappeared. Someone shot at the nephew-in-law, Brandon Boudreaux, near his home in Arizona, but fortunately that one did miss. And Tammy Daybell then died suddenly and mysteriously, which at long last cleared the way for Lori and Chad to marry just 2 weeks later with no children in the home to care for. So the case began to unravel when JJ's parents called in a welfare check when they couldn't get hold of him, and law enforcement tracked Chad and Lori down to Hawaii, where they were enjoying a romantic interlude together. Lori's children were then found buried in Chad's backyard, one of them in a pet cemetery. Now, last year, Lori had her trial. She was convicted of murder, conspiracy to murder, on all counts, and she was sentenced to 3 consecutive terms of life in prison without the possibility of parole. She was also sentenced to 2 additional life sentences, just in case, and 10 years for grand theft to be served concurrently. This is as strange and dark a case as you will ever find. And now all eyes are going to turn to Ada County, Idaho, where Chad Daybell goes on trial starting April 1 with jury selection. So several people have asked me, is anything going to be different? And that's what I want to cover today, because I think the answer is yes. I don't mean that the result will be different. I mean that the trial itself will be different. I want to explain why I think it is. I'm going to give you 7 different reasons. And then at the end, of course, I'm going to give you, I always do this. I come up with a number and then come up with a few more things I just really want to tell you about. Let me say thank you to a few people. Thank you, Molly. I really appreciate that very much. And Andrew, I appreciate that as well. Yes, definitely. Please hit the like button. It really does help the video. And Mitt Spunky, thank you so much for the gift of a lawyerly membership. We are glad to have all our members. We're going to be using some emojis tonight. So if you're a member, you will enjoy that. So here is reason number 1. And it might seem counterintuitive, but reason number 1 why this trial will be different from the first one is there's already been one trial. I mean, that seems crazy, right? Isn't that a reason for them to be the same because it already happened? And on the surface, the answer to that is yes, but it's also a critical reason why the case will be different. It's natural for us as people hearing witnesses to expect them to be consistent. So if a witness changes what they say, that's really confusing. We find ourselves asking, okay, which of those statements was correct? Is this just a witness who lies? We end up with a lot of questions, and it undermines their credibility. And credibility of witnesses is the name of the game at trial. When human beings talk, they tend to contradict themselves. So the more someone talks or testifies, the easier it is to cross-examine them. It's the same principle of why lawyers often advise their clients not to talk during police interrogations. Cross-examination is really critical because it's the time when one side tries to convince the jury that this witness can't be believed. This is when one side puts up the witness and does what's called direct examination, and then the other side asks cross-examination. And their goal is to say, now undermine what that witness said that helped the first side. Now, the jury is going to decide whether or not it believes the witness. So in many cases, the fact that a trial happened before helps both sides because they may find contradictions in what one side may find a contradiction in what the other side said, and then vice versa. But in this case, it's going to help Chad's side pretty much exclusively because Lori called 0 witnesses, absolutely none. So every single witness that testified for the prosecution. So this will be some advantage. Is it going to change things? That's a different story. But this will be an advantage as the lawyers prepare for trial because they know what the witness will say and they can find things to contradict inside there. I want to show you an example of a situation from the Lori Vallow Daybell trial where one of the lawyers walked into a buzzsaw with the testimony of Lori Vallow Daybell's friend, Audrey Baratario. Sorry. She was on the stand and she pulled out some surprise testimony. Here's how it worked. Lori's attorney had what should have been pretty good cross-examination for the witness, but it ended up backfiring. The witness said she stopped being friends with Lori, and the attorney is trying to make the point, which you'll watch in just a second, that the witness was just fine hanging out with Lori, being friends with Lori, until these charges came up. In other words, saying, you never saw any problem. It isn't like Lori is a bad person. So let's go ahead and hear. And by the way, this is audio only because that's all that was available from the first trial. There was no televised. There was nothing televised as far as the testimony.
You were having fun with your friends on the beach in Hawaii, right?
Yes, but it was uncomfortable because they were talking all the time about zombies and about Melanie's kids.
And so you felt so uncomfortable around them after Hawaii that instead of going home to Missouri, you went to Idaho with them.
I wanted to go home to Missouri.
But they made you buy a ticket to Idaho instead of Missouri.
No.
Okay.
But I have a big heart.
No.
And I didn't want Melanie to be alone because she said she was going through a hard time.
So that's pretty good cross, really. And let me make this a little bit different layout. So that's pretty good cross-examination, really, from a lawyer's standpoint under the circumstances. It's not an easy case. But there was a fact that the lawyer may not have known about. Now, when one side asks a question, sometimes other questions that might not have been relevant now suddenly become relevant because the witness is entitled to explain something that came out as a result of that testimony. We call that opening the door. So the defense lawyer has now opened the door to the question of why they are no longer friends, why they broke up as friends. And the prosecution goes right through the door, asks that question. You're going to hear the defense lawyer object and say, no, it's just too late. So the defense lawyer is going to object to that. And not successfully, it's going to come in, and in is going to come some very chilling testimony that makes Lori look basically nothing short of evil.
I think defense counsel kind of asked you about this friendship and why you terminated it, and you said that you were scared or in fear. What threats did she make to you?
Your Honor, I think this is outside.
She threatened to kill me.
I'd object.
Hold on just a minute. It came up on cross-examination, so it's within the scope of cross and proper redirect. Ms. Rawlings, you can re-ask the question.
And Lori and I were the only ones in the home, in her place at the time. And I told her that I was going to go upstairs and pack my bag and just go to bed early because I didn't want to spend more time with her. And as I went to go and do that, I asked her the question, is there anything weird going on that I don't know about? And she said, no. What do you mean? And I said, I don't know anything. And she said, no. So I took her at her word because I'm a trusting person. And as soon as I turned to start to go up the stairs, she started laughing. The kind of laugh as if you're laughing at someone or think something's hilarious. And she said to me, you're so naive and too trusting. You're like a little child. You'll believe anything anyone would tell you. And she said, you think the world is all unicorns and rainbows. You go around helping people and serving them. Well, I've got news for you. Not everyone's a good person. And not everyone can afford to be so nice and kind. And then she said that
So I want to just focus on what threats she made to you.
She threatened to kill me.
Okay. Did she say how?
Yes. She said that she would cut me up. And something about that she wasn't in the mental place to do that, but that she would get herself in that place to be able to do it. But that she didn't want to have to because it'd be so messy and there'd be so much blood. And then bleach and something about trash bags. And that she would bury me worse.
So the defense did have access to the grand jury testimony by this witness. So the defense lawyer pointed out that this testimony about this chilling event that the witness is claiming happened didn't come out in front of the grand jury. But the defense lawyer had opened the door, so the testimony came on in. And obviously the prosecutor knew about it because went straight to that question and to ask more about it. So here is what the defense lawyer did to try to fix the problem that it had come in at Lori's trial.
Would ever find me. Okay.
We're about to switch over. Give it a second.
And you have previously testified under oath, swearing an oath that you'll tell the truth. You have previously testified at a grand jury hearing. Do you remember that?
Yes.
Do you remember taking an oath to tell the truth, the whole truth, and nothing but the truth? Do you remember that?
Yes.
And do you remember your testimony that you did not say anything like this?
I was scared, and she had said that if you ever tell anyone, I'll come and find you in the dark of night.
So you now want the jury to believe that even though you previously testified under oath and nothing of this sort was talked about, that you come here today and say you are so scared, that's why you didn't previously testify about it.
Objection, Your Honor. Argumentative.
It's overruled.
What was your question?
You want the jury to believe that you just didn't make this last crap up.
I did not make it up.
But you acknowledge that you did not say this when you previously testified in support of probable cause, right?
Yes. Chad
Okay.
and Lori.
So let me pull this out and so I can talk to y'all a little more directly. I am curious. All we have is the audio, and I sure do wish I could have a visual of what she looked like when she said this, but I'm really curious about what you thought about that testimony when you heard it, her description of what happened. If you're one of our members, and membership is just a way of financially supporting the channel, then we have special emojis. So give me a special emoji, put a 1 in front of it so I know which question you're answering, and just give me an emoji that is how you feel about that testimony. But if you're not a member, we totally understand, and we are delighted to have you too. You never have to be a member to watch one of the videos, but we would love for you to subscribe. That's totally free, and we'd like to have you back. But if you would just put the number 1 and then a word that describes how you feel about the testimony, whatever comes to mind first, what is it you thought about that? And it could be anything from you thought it was great to you thought it was terrible. I'm really curious just kind of what you thought about that. But let's think about how this plays out in Chad's trial, because his lawyer is going to be forewarned about this, will not make that exact mistake. Other mistakes, sure, you always make a mistake at trial, but not that mistake. And if it does come in, then he will have combed through the grand jury testimony to find places where Audrey was asked about things pretty close to that and didn't come up with that story. So if the defense can find anything like that, it will work to discredit Audrey and to make the jury question whether they should believe her testimony. That will be the point of the cross-examination. So the trial will be different because the lawyers will be prepared to ask questions, to know what the witnesses will say, and to come up with those things that will make it different. So before we hit number 2 on our reasons that it will be different, I want to say thanks to Atticus. And I totally agree. We have the absolute best mods and best chat on YouTube. I think everybody is just so pleasant, so nice, and I really appreciate it. Strong opinions, but always said politely, and it just makes all the difference to have that. And this is definitely different from the Delphi case, which is also bizarre and also absolutely fascinating, and something clearly that I think the world needs to be paying attention to. It's an important case. It has a lot of issues that need to be addressed. And I want to thank Mitt Spunky too. Thank you. I appreciate that. And I appreciate your support. So point number 2 that I think is going to make the trial of Chad Daybell pretty different is the death penalty. One of the most significant differences between the two cases is that the prosecution is asking for the death penalty in Chad's case. Now, to be clear, the prosecution also asked for the death penalty in Lori's case, but the court ruled it out in Lori's case as a sanction because the state had not met the deadlines for turning over information. And it was going to keep Lori Vallow Daybell from having time to prepare for trial. She had invoked her right for speedy trial, and it was just a matter of weeks until her trial when the court, I think 2 weeks, when the court took the death penalty off the table. So let's go ahead and listen to
I
that.
haven't found here any misconduct of the state. However, procedurally,
Let me give a little intro because I think I went too fast into that. So this is the court explaining why he is going to take the death penalty off the table in Lori Vallow Daybell's case.
disclosures were late and deadlines were missed. On weighing the facts of this case then against the rights of the defense to have an objectively reasonable time to prepare for a death defense, the court determines that the late disclosure of discovery has materially prejudiced that right. The court also notes that this is not the result of a single discovery violation, but rather the cumulative effect of a deluge of discovery coming too close to trial, culminating in a large discovery disclosure a day after the scheduling order mandated, and finally even more discovery that was not provided to the defense until, according to the record, March 13th. The defense cannot be required to review that quantity of new discovery only 2 weeks before jury selection begins. This has prejudiced the defense. I've cited the affidavit of the mitigation person who has said unequivocally they simply cannot have time to prepare and go through for mitigation the late disclosed discovery. Thus, considering everything, the court is required to fashion a remedy that honors the rights of the parties, the fundamental right to a fair trial, and the right of the state to bring to trial those who are accused of a crime. In balancing these rights, the court concludes here that as an appropriate discovery sanction, the state will be precluded from seeking the death penalty at trial, and the state's May 2nd, 2022 notice of intent to seek the death penalty will be stricken.
All right. So that was the reason that the death penalty was off the table for
They were
Lori Vallow
friends.
Daybell.
You were having fun with your friends.
There. Let's remove that for sure. So since Chad had waived his right to a speedy trial, it didn't apply to Chad. That ruling didn't apply. He had plenty of time to prepare. He had enough time to get the discovery in, make his preparations. It wasn't relevant. So he did argue that it wasn't fair for him to be tried and the death penalty to be on the table if the death penalty was not on the table for Lori Vallow Daybell. But the court said, no, these are two different cases. And you have plenty of time to prepare. There wasn't the same reason to take it off the table. And the state can prosecute you under the death penalty if the state chooses to do so. And it does change the trial. The stakes are higher. Appeal is 100% certain. In fact, multiple appeals are certain. The appellate courts will look very, very closely at the case because they know the stakes are so very high. Even procedurally, the trial is going to be different. Let's take a look at why. Here is the Idaho statute. Let me get everything arranged so I can talk to you about it. Idaho 1925-15. And what it explains is there are going to be two different phases of the trial if Chad Daybell is found guilty. We can go over this in more detail in another video. I'm just going to do a short version today. The first phase is going to be guilt or innocence. Then the second is going to be devoted entirely to the death penalty. The same jury will sit if possible, but there's a provision for the court to pick a new jury if that's simply not possible. So here's what it says. It says, first, the state has to file a notice of intent to seek the death penalty. That happened. And a special sentencing proceeding shall be held promptly. Now, it doesn't say the next day, immediately thereafter. There may need to be a gap of time for the parties to prepare. The purpose of it is to hear all relevant evidence and arguments of counsel in aggravation and mitigation of the offense. Information concerning the victim and the impact that the death of the victim has had on the victim's family is relevant and admissible. So that means the people who testified at Lori's sentencing, again, could testify for the same sort of reason. Such information shall be designed to demonstrate the victim's uniqueness as an individual human being and the resultant loss to the community by the victim's death. So all of that is going to be allowed in. And as it says in B, the same jury shall hear the special sentencing proceeding if it is impracticable, can't be done, not really, just not practical, to reconvene the same jury to hear the special sentencing proceeding due to an insufficient number of jurors. The trial court may dismiss that jury and convene a new jury of 12 persons plus alternate jurors. So that is clearly a possibility. And that there would actually be a new jury. But I would be willing to bet that what the court would like to do is have the exact same jury sit in there. That would be so much easier from everybody's standpoint. They've already heard the evidence. It doesn't have to be presented again. It could just be the little bits that relate to the actual sentencing. But it won't be a small proceeding. It will be a significant proceeding on its own. So the third way that the case is going to be different, I think, is the charges, because there is a full murder charge against Chad with Tammy that wasn't in the case with Lori. Now, I went ahead and did a chart because to me, I like to see things visually. So these are the charges, and I'll make that a little bigger. So these are the charges that were in the original indictment, or actually the amended indictment filed by the state. So you can see that they're divided into counts that relate to the death of Tylee. She's the 16-year-old. JJ, he's the 7-year-old. Tammy, she's the wife of Chad. And Tylee and JJ and Tammy. So there are 3 counts of conspiracy to commit first-degree murder. Tylee, JJ, and Tammy. And you can see the defendants for the conspiracy to commit first-degree murder and grand theft by deception related to Tylee. The defendants charged, or conspirators, because Alex Cox is dead, the conspirators are Chad, Lori, and Alex. Then there's a first-degree murder charge for Tylee, and Chad and Lori were charged with that. Conspiracy to commit first-degree murder and grand theft by deception related to JJ, again, Chad, Lori, and Alex, and again, a first-degree murder charge for JJ, Chad, and Lori. Then when it comes to Tammy, there's a little bit of a difference. With the conspiracy charge, it's the same, Chad, Lori, and Alex. But when it comes to the actual first-degree murder charge, only Chad is charged with that. Lori was not charged with that particular count. Lori was charged with grand theft felony related to Tylee and JJ, and with continuing to claim benefits for them and to accept benefits for them, even though she knew they were dead. Chad is charged with insurance fraud related to the death of Tammy, where he collected insurance for Tammy's death. And that's the argument for that. So now the next, Chad has those 2 charges that are just for Chad. He has the extra first-degree murder charge related to Tammy's death. Lori was in Hawaii when Tammy died, so she's not being charged with first-degree murder, only conspiracy to murder. And I want to address that number 8 right now. I want to talk about the insurance fraud that Chad is charged with, because that's a 4th difference in the case. The insurance fraud is going to be charged. Give me just a second to pull that out. Okay. Tammy Daybell actually had 2 insurance policies, one for $300,000 and another through her school for $130,000. In 2018, the policy Tammy got through her school was for $10,000. But in September 2019, a matter of weeks before she suddenly died, she upped her life insurance from $10,000 to the absolute maximum, which was 5 times her salary, or $130,000. And Chad was very quick to collect on it. We heard that in Lori's trial. By the Monday after her death, he had already obtained 6 death certificates, ordered another 8, and he phoned the school to ask about how to collect the insurance. Now, we know a little bit about how Chad's going to defend himself in this charge that's just against Chad. And we know that based on Lori's trial, because we did hear that Chad is going to be arguing that Tammy's increase in life insurance was just natural timing. It didn't have anything to do with her murder. The school only allowed the employees to change or increase their insurance limits once a year in September when school started. So the reason she upped it was just that's when she could. Chad didn't even go with her to the meeting. And therefore, it had nothing to do, Chad's going to say, with why she died. It simply was a coincidence that she happened to raise her insurance right around that time. And she did it on her own. So with those points, where we are so far, give me an emoji on how you feel Chad ought to feel going into the trial. Or if you are not a member, we still love to hear from you. Put a number 2 beside either your emoji or your one word that is how you think Chad should be feeling going into trial. What do you think so far? And let me say some thank yous to people. Janet is using her milestone. She's been a member for a month. We started our memberships just a month ago. So Janet's been a member the whole time. So thank you, Janet. I appreciate it. And hey, back to you. Mitt Spunky has gifted 5 Lawyer Lee memberships and another 10. Thank you so much. I really appreciate that. And JK Min also gifting a Lawyer Lee membership. That's great. People have been having so much fun using the emojis and communicating back and forth. So I'm really glad to have all of you as new members. So point number 5 that I think is going to make Chad's trial different from Lori's is the evidence related to the Arizona case. During Lori Vallow Daybell's trial, the court allowed the prosecution to go into what I thought was frankly great detail about 2 incidents that had occurred in Arizona. Charles Vallow, who was Lori Vallow's 4th husband, was killed while he was still Lori's husband by Lori's brother, Alex Cox. This was shortly before Lori and Alex abruptly moved to Rexburg, Idaho to be near Chad. Alex claimed the shooting was just self-defense, and Alex is no longer around to defend himself, but prosecutors think that it was actually planned in advance by Lori and Alex. Lori is also charged with a second incident in Arizona with conspiring to murder Brandon Boudreau. Brandon was her nephew-in-law. Someone shot at him not far from his house, and the prosecution believes it was Lori's brother, Alex, again, and that he was working at the behest of Chad and Lori. But here's the problem, in my view. Arizona has charged Lori in those crimes. In fact, she's been moved down to Arizona. She's currently down there awaiting trial on charges related to Charles Vallow and Brandon Boudreau. But the Arizona Maricopa County Attorney's Office elected not to charge Chad Daybell with the shooting of Brandon Boudreau or the death of Charles Vallow. So he has not been charged in those, where Lori has been. Now, during Lori's trial, I felt like the court had gone pretty far out on a limb, letting in so much from the Arizona cases against Lori. The argument was and frankly, the prosecution did a masterful job explaining it all as one long crime, basically, one long arc of crime, and the same pattern used over and over to eliminate people who were in the way of Chad and Lori's great romance and their expected leadership role in the end times. But it was a hard choice because, in my opinion, it's going to be a centerpiece of her appeal. That's because I think it's always more difficult to get in other crimes than anything related directly to the crimes that are in front of the jury. But it's got to be a more difficult choice for the court when it comes to Chad. He hasn't been indicted. He hasn't been charged. The local district attorney in Arizona said they don't plan to charge him. That suggests they don't think they have enough evidence to prosecute him for the murders, whereas they think they have enough for Lori. So the court then is faced with a problem. The court has to really figure out what evidence should come in in this case against Chad, because for sure this would be an appellate issue if it comes in. And death penalty cases already have multiple appeals. In my view, would make it more likely that the case would be reversed. The court just has to think long and hard about this. If the appellate court says that the trial court was wrong, that the Arizona cases should not have come into evidence, it's a problem. And it's not just an issue that affects something like sentencing. If the judge got sentencing wrong, they could just resentence. They could just redo that part. If something went wrong with the death penalty phase, they could just redo that phase. But this is bigger. This is an issue that would affect the actual trial itself. If the jury heard evidence that should not have been admitted, that was part and parcel of what they considered as they made their decision about guilty or not guilty, then it seems to me like everybody would probably be looking at a retrial. So that's why it's so critically important. So the seventh reason now that I think the trial could be different is that there's a new order excluding witnesses, but making a special ruling. Let me explain that. It sounds complicated. Melanie Pawlowski may testify this time around. We have some tea, basically. I'm going to show you a court order that may seem dull and dry, but I'm going to tell you it is not. It has some real tea. So let's add this to the stage, and let me switch over to this new order that's been put in. Okay, it says order excluding witnesses. What they're talking about when it says order excluding witnesses is that, and it's a very typical provision, that a court will say, the parties will ask and the court will say, I don't want witnesses hearing other testimony before they get on the stand. Once they finish their testimony, they can sit in the courtroom and listen to the trial, but they can't come into the trial, hear everybody, and then get on the stand. Or, since this case will be televised, they can't watch it on TV. So here is what the court ruled, though. Typical rule saying that the witnesses shall be excluded from observing or listening to other witnesses' testimony during trial. Very normal rule. But look at that second paragraph. Both parties have raised concerns with the court that there may be witnesses who would intentionally observe or listen to the proceedings in order to be excluded from testifying at trial. Upon consideration, the court determines that the administration of justice is served by requiring counsel to inform witnesses of this order. Further, if after informing witnesses of this order, counsel has ongoing concerns that witnesses intend to violate this order, counsel is ordered to submit to the court for in-camera review the names of those witnesses. The court may thereafter initiate proceedings as the court deems necessary to ensure the right to a fair trial is upheld. Now, what on earth is that about, you may be wondering? Well, to set the stage, one of the most intriguing potential witnesses of all is Melanie Pawlowski. Lori Vallow's niece, Melanie, was in the group of women who followed Chad. She helped Lori attempt to cast demons out of people. And let me show you, I've got a picture of her here from an interview. Wait, nope, that's not it. Well, maybe I don't. So I will pull that out and just talk to you. Okay. So, of course, remember that someone attempted to assassinate Melanie's husband, Brandon Boudreaux, in Arizona. That's one of the two cases Lori has been charged with in Arizona. Brandon happened to be in a very bitter custody dispute. Prosecutors believe that basically Lori called in the hit and Alex Cox, her brother, tried to shoot Brandon, but fortunately missed. Melanie has never been charged in any of this, but uncertainty about why Brandon was so important to Lori that she would decide he needed to be eliminated has been out there. Why did Lori think this was so important? But no one has ever said that Melanie was involved. By the time someone shot at Brandon, Lori lived in Idaho. Why did this seem so important? So why did she need to kill him if he wasn't really in her way or interfering with her? But no matter what she said, Melanie's testimony could have been a game changer. She had potentially bombshell evidence. She was supposed to testify at Lori's trial, but she didn't. And here's the really weird story of what happened. After her divorce, Melanie married a new person, Ian Pulowski, very quickly. They had known each other only a matter of a couple of weeks, if I recall the testimony. But their marriage was a little strange. For example, in their first 2 weeks of marriage, Ian wore a wire and actually recorded conversations that he heard. So bizarrely, he did that on behalf of the FBI. So he married a woman, even though the FBI wanted him to wear a wire and tape her without her knowing it. And Ian testified at Lori Vallow Daybell's trial. Melanie was expected to testify too, but she announced that she had watched some of the testimony of her ex-husband, Brandon Boudreaux, who also testified at the trial. That was against the court's rules. Witnesses were not supposed to watch any of the trial until after they had testified. Then in the middle of trial, we got some sort of confusing news. Melanie Pulowski was expected to testify, but now the prosecutors had let her go home, which was back in Arizona. And the reason was, we heard that she had read headlines of what Brandon Boudreaux had testified to. Now, at the time, we were told that she had read those headlines because of their custody dispute, and she just wanted to know more about what he had said. She had already testified, and she was just listening to what he said, or reading about it, I should say. But this new order suggests that some witness might try to listen to things so they could not testify. Is it Melanie? We don't know. But that certainly was a very strange set of circumstances that happened during the trial of Lori Vallow Daybell. She's a critically important witness and could have very important information. So both sides seem to be concerned that somebody, we're not told who, somebody might get the idea that by watching or listening to testimony, they could get out of testifying. So, and I think I said that was number 7. That was number 6. Number 7, the number 7 reason that I think that Lori's and Chad's trials could be really different is family participation. Now, at Lori's trial, Lori's sister testified not for Lori, but for the prosecution. Her mother and father, Lori's, never showed up. So Lori's family was either absent or hostile or just not participating in the trial. Chad's family could be an entirely different matter. And what I had up on screen just a moment ago, that is Chad's family during an interview they gave to 48 Hours. They have insisted that their dad is innocent. They have seemingly stood all together saying Chad is not at fault. Our mother's death was an accident, and Lori Vallow Daybell is to blame for everything else that happened. So at all, to public appearances at least, they have staunchly supported their dad. Furthermore, the parties have agreed that journals of 2 of Chad's adult children can be admitted at trial. We don't know what's in those journals. It could be that both sides are convinced they're going to see helpful information, and that's why they stipulated to it. It could be that by stipulating that the journals could come in, Chad was sparing his children, who are all adults, but sparing them from having to come and testify at his trial, because maybe they've stipulated to that, so no one has to authenticate it. They just agree, yes, this is a journal. And that way they don't have to get on the stand, the kids don't, and they don't have to say anything about it. It can just be read into evidence. They are in a very awkward, precarious situation because the case alleges that their father killed their mother and should receive the death penalty. In whatever capacity they participate, if they show up at all, it will affect the dynamics. People are really going to be watching this. And another thing I want to point out that is going to affect the trial throughout is that there are different lawyers and that it's going to be shown on TV. Just the fact that different lawyers come mean they bring different ideas. I don't see any way Chad's lawyers put on no case at all like Lori's did. I cannot imagine them not presenting some witness, somebody to come and talk about what happened. And that will be different from how Lori's team handled it. Also, the fact that it's going to be broadcast definitely has an impact. Lori's trial was obviously followed closely by not just by us, but by many news media and by many news outlets. It was intently followed, but that's different from being broadcast. And so Chad's trial will be broadcast, and that's going to make a difference in terms of the ability of people to follow it, to understand it, to see what actually comes out in the testimony. For example, the witness where I said earlier, boy, I sure would like to have seen them as they did that. That's going to be different. So I have a few more people that I need to thank. Let's see, Tom 23. Thank you very much, Tom. I appreciate that. And Patricia Marie, thank you both. Thanks very much. So put your questions in the chat now. I've got a couple more things to say, but if you would do this, if you would put question marks at the beginning, it makes it a lot easier for me to spot your question. There are a bunch of comments, and sometimes it can be kind of hard to find them all. So if you would do that, I would really appreciate it. And while I'm waiting to find the questions that are in, I also want to say thank you always to Marlon and Mama Pinks for doing our moderation. We are so lucky to have them just handling the chat, making sure it stays a happy, pleasant place to be and participate. Atticus wants to know whether stipulations are usually settled before trial. I've heard of the odd one during trial, but are most settled ahead of time. Well, by definition, it's just when the two sides agree on something. Obviously, they have more time to kind of think through that in advance and come up with their lists of exhibits they're going to stipulate to, various things. It can happen during trial. It's just that everybody's pretty busy, and usually those have kind of been set. So I think that's why it's maybe a little less common during trial, but it definitely happens during trial. And we saw several examples of that during the case for Michelle Troconis, where they would come up with a stipulation during trial. They'd have a disagreement and they'd figure out a way to work together on that. Annie K asking, what's my take on the Lori and Chad having sincere religious beliefs, delusions versus finding ways to avoid prosecution or create insanity pleas? You know, Annie, I don't know what for sure anyway, what I would have thought before Lori Vallow's statement at her sentencing. After that, I 100% believe that Lori had sincere beliefs that, whether they make sense to me or not, were sincere to her. And I don't think she was in any way trying to create an insanity plea. For Chad, he hasn't even gone after that. I guess he didn't really have any good argument for that. So as far as sincere religious beliefs, I would have to find out more about what he says. We just don't have enough information. We'll have to kind of watch him at trial and see what happens. That's one of the things that we will be learning about. Deidre says, is Chad required to pay back the life insurance? You know, there was a question that I remember being really puzzled about. I think I even commented on it at the time during Lori Vallow Daybell's trial, where they said to whatever witness was on the stand, isn't it true that the insurance companies wanted back all the money that Chad got? They didn't say the insurance company got the money back, but just that they wanted it back. I was surprised. How did that help Lori? I couldn't figure it out. That sort of suggests, yeah, the insurance companies thought this was fraudulent. So how does that help? Why are we asking the witness this? I couldn't figure it out. But I don't know. He probably had spent a good bit of the money. As I recall, he distributed it to the children. So I don't know what came of that. Whatever money he got, I don't know how he distributed that. I know that he did pay some amount. I think he turned his house over to his lawyer. Just, here's the house. And so the lawyer now owns a house in Chad's hometown. All right, let's see. Oh, I'm so excited about all the new members. So glad to have all of you. All right, I'm looking for more questions. Bell Moon asked me, Chad's lawyer went to Lori's trial every day. How is he not prepared? You know, that definitely would help. It definitely would help to get prepared, to have been through all of that and seen all of that. But, you know, It honestly, Bell Moon, it's one of these receding in the distance kind of things. It doesn't matter how long you work on a case, you never feel like you were totally prepared. There's always something more that you wish you had done, something more you wish you could do. And so he argued that he needed help and support, and I don't doubt that at all. The prosecution had numerous lawyers on its side, and they can split that up. For someone, any lawyer to do a death penalty case completely by themselves is a huge order. So he asked for additional help. And as far as will he be prepared? As prepared as anyone feels like, probably. You never feel really prepared. Forever Red wants to know, can Lori testify for the defense? The answer, Forever Red, is sure. Lori could be a witness. That's definitely possible, but there is, in my view, zero way they would put Lori on the stand, because it would just be such a disaster. I mean, all you have to do is go back and listen to her statement at the sentencing, and there's no way they can control that or have any idea what is going to come out of her mouth. And that is a huge risk, especially in a death penalty trial. You don't want any risks as an attorney in the death penalty trial. And boy, would Lori be a big risk. Marcy wants to know, wouldn't a journal be hearsay? Exactly the point, Marcy. Exactly. You have nailed it. Yes, that's the issue. And that's why they stipulated to it. It would be hearsay unless the person comes in and says, that's my journal and I wrote that down. And therefore, the witness would have to be at trial, would have to get up on the stand, would have to say that. So the reason they stipulated might be because of the fact that the kids now won't have to testify. It's already in evidence, and people can just refer to whatever it said. And that's what I think they mean by that it's stipulated. That's at least how I read the document that they filed. Rosie Burns wants to know, how long could jury selection take? Could take a week, really could. Might not. I tried really hard to remember how long Lori Vallow Daybell's jury selection took. I would expect this to be a little faster. Just having run through it once, you can kind of move a little faster. But I could not remember how long it took. I don't think it took a whole week. So, but I can't remember for sure. It'll be a substantial amount of time. Okay, looking for my question marks. Janet wants to know, do we know what Chad's grown children think? I know they have tried to stay out of the spotlight, and that is certainly the case after that 48 hours segment that they did. So when they first when things first came out, they were very adamant that their dad was not involved. And we knew that by what they said to 48 hours. But we have not heard much since then. At least I haven't. I'm not aware of anything more that they've said. And it may be that they were told, stop talking, don't talk to the media. That would be a common thing a lawyer might tell the family. Lisa wants to know, how do they read journals into evidence? You can't cross-examine a journal. And I don't know exactly what they plan to do with those. When they stipulate, I think they have only stipulated to the authenticity. So we will see what happens from there. But all we got was a list of exhibits that have been stipulated to. That's what we have so far. And we'll see what they do with that. Drew P. wants to know, if Chad and Lori were so ardent seekers of the afterlife, why are they so afraid of the death penalty? Well, I don't know. I think you're outside my field, Drew, but there's a good question. Robin Ruggiero wants to know, will Chad testify? I don't know, Robin. We obviously know what the rule of thumb would be, and we know what Lori's team decided. They decided no, and that would be the general rule of thumb is no. Chad might have some things he needs to explain. There isn't, well, let me correct that. There isn't a ton to connect Chad to the deaths of JJ and Tylee, except big flashing sign, the fact that they were buried in his backyard. Okay, that's something really, really big, right? But would he need to testify around the death of Tammy? Maybe. We'll just see how they decide to get in, because he was interviewed. There were initial inquiries into it, and there was an initial autopsy that said, she died of natural causes. So that may be something that isn't necessary for him to do, but we'll have to watch and see that. I'll take a few more questions. Patty says, can you explain why the death penalty was not on the table for Lori, but is on the table for Chad? So, and Patty, we did cover that earlier, but I can tell you that real quickly too. And I played the clip for it. Every time I say this, somebody says in the comments, you are wrong about this. So I always play the clip because I'm telling you, that's what the judge said. But okay, what the judge said was the state is slow in getting some of the discovery to Lori Vallow Daybell. Her trial is in 2 weeks, and they've been too slow on the discovery. They were supposed to get this stuff out. I don't find that they did something wrong, but this was a violation of the deadline on the discovery. They didn't get it in time. And for that reason, I'm striking the death penalty because she has trial in 2 weeks, and it's not fair to make her try to prepare when you haven't given her the information until the last minute. But the court said that doesn't really apply to Chad. He had another year to get prepared. He had plenty of time to look at this evidence, to hire experts, to be able to respond to it. So Chad can move on to trial with the death penalty because he had the chance to get prepared. And so it was, the judge called it a sanction, and it was related to discovery. So that's what he said. And you can go back and listen to the clip and hear a little bit about it. Just Me wants to know why Melanie Boudreau watching or reading meant that she was excluded. Most witnesses know what's happening, and she couldn't have learned anything new. The idea behind that, Just Me, is that if a witness sees what other people say, maybe it'll influence what they say. It would be better if they came in and just answered the questions, not knowing in advance exactly what the other side would say, what people before them have said. Maybe it would change what they said or influence it. And so it's a very, very common thing that lawyers ask. I want all the witnesses sequestered. I don't want any of them coming in or hearing any of the testimony. It's just that it's harder here where it's broadcast and where there's a lot of their headlines and their articles and things that somebody might just see scrolling on their phone or looking at a newspaper. So for that reason, Melanie Boudreau happened to see some of those things. And she said, I saw some coverage, and apparently had actually looked at some of the coverage related to Brandon Boudreau. There was very little that drifted out to us. So I'm sort of piecing it together based on what we've heard. That's not exactly possible to answer, but that's why. Yes, the witness would know things based on what happens before the trial, but they don't know what happened right there at the trial. All right. John Pryor isn't death penalty qualified. How will the court handle this? Well, I believe that John Pryor was getting in assistance. That's what they were working on. And I believe that that occurred. And that is a significant issue if he's not death penalty qualified. But the court had Chad Daybell. He explained to Chad Daybell everything about that. And Chad Daybell waived it all and agreed that he was okay with this lawyer representing him. So that was thoroughly covered by the court. He was very careful on that score. Amy wants to know whether I think Lori will be found guilty of her previous husband's deaths, and can Chad's defense bring the suspicions up as part of his defense that she was the brains of their horrible acts. That's a great idea, Amy, actually kind of turning the evidence like that. Like, oh, well, actually, it's all her fault, and this shows it. Nice turn. As far as whether I think she'll be found guilty of her previous husband's deaths, the only one I know that she's being prosecuted for is Charles Vallow. And I honestly would have to wait to see more of the evidence to say whether I think she'll be convicted of that. We know that she was indicted even before this case where she was convicted in Idaho, but it's just now moving to the stage where she is supposed to go to trial this summer for at least one, maybe both of the other two cases that she's charged with: the death of Charles Vallow and the shooting at, but not hitting, Brandon Boudreau. So we'll wait and see. Let me flip over here and say thank you to a couple more people. Jersey Jim, we are glad to have you. Good to have you back. And Patricia Cox, thank you both for the super stickers. I really appreciate that. And let us take a look at a few more questions. Oh, number one fan asking for hit the like button. Please do. That is such a help when you do. All right, let's see. I'm looking for the question marks. There we go. Angie, what did actually Lori say at sentencing? It's one of those things, Angie, where I couldn't even duplicate it for you, but I had a video on that. When this processes, I'll link it, but you can just go to my channel and look at the Lori Vallow Daybell playlist, and you'll see the video I did. I did a whole video where, okay, this is what she said. It just was sort of unhinged. She said, for example, that she thought her children were happy and busy, and Tammy was her friend and was happy and busy. And there was no sort of recognition that any of this was bad. It seemed like she felt like this was just what happened, what needed to be done. It didn't seem to resonate on an emotional level. So you can watch my video and you can kind of decide for yourself what you think. But we went through that and I think you'll be real interested in that video. Molly wants to know, Chad Daybell told cops he hardly knew Lori Vallow Daybell, even though they were married. Do you think he stopped protecting her and now will blame her? So I think, Molly, that was actually before they got married, but a matter of weeks before they got married, like, or maybe they were even married. I honestly can't remember the timing of that. Do I think he stopped protecting her and will blame her? 100% yes. Absolutely yes. No question. I think he will blame her. In fact, one of the things they wanted when they started the trial, before the trial, they asked the court, will you please tell the prosecution that they have to say Lori was in charge of everything, because they said something, the Chad's team said that's pretty much what they said at Lori's trial, and they have to be consistent. The court said that isn't really what they said, and that's not what we mean by being consistent. They don't have to say, come into Chad's trial and say, well, we think Lori was the ringleader, but Chad also was guilty. So that's not how they have to argue it. Forever Red, how long is this trial supposed to run? I saw 8 weeks, 6 to 8 weeks. And obviously that depends, but that probably includes the death penalty phase, which I would expect would be a significant phase in and of itself. It will be, a significant amount of time. Sherry Wilson, death penalty automatically gets 3 appeals. It gets multiple appeals. You go through the state courts, you go through the federal. Normally, that'd be a really interesting question. I'm going to see if I can find what's the average number of appeals that you get on a death penalty case. It runs through multiple times, and then it runs through on, it might initially be on the case, and then it's going to be on the method of death penalty. And so it goes for a very long time, but I don't know the answer to the number that's average, but I'm curious. Let's see, looking for, there we go. Holly, I don't understand why Chad has due process and Lori had death penalty, not due process. No, they both have due process. Has death penalty and Lori had a chance to get the death penalty off the table. So that's a great question, Holly. I answered that earlier in the video. And I also did a whole video on the death penalty. So definitely go back and look at that, because I think it's an important question and you'll definitely want to know more about that. Raven's View, why are these people who believe they are best friends with Jesus so afraid of the death penalty? Yes, you're not the only one wondering that, Raven. Other people have asked that question as well. All right, I will take one more question. Let me say, Rexine Whirl says, first month member. I'm so glad. And you're enjoying the explanations. Good. I'm glad to have you as a member. And John is asking me, what's the possibility of a Delphi update? Is that a crazy case or what? I definitely want to do another update on that. I think I already have Wednesday sort of planned. And so I think that'll probably maybe be Friday. Maybe I can do a Delphi update on Friday. I was hoping to get the judge's ruling on some of the last couple of issues, and then we can maybe talk about how that will impact trial. Those haven't, at least last I looked earlier today, there were some rulings that were still missing that I wanted to find out. That is really fascinating, particularly with the loss of that big swath of interviews. That is really absolutely fascinating. And I don't know how that's all going to carry out. So, okay. Last question is, Mimi, does Chad's agreement to keep Pryor preclude a claim of inadequate legal representation? So what Mimi is saying is, okay, Chad agreed to keep his lawyer. Is that going to preclude a claim that the lawyer was not an adequate legal representative for him? In other words, that he can't appeal, saying what's the kind of normal claim that there was ineffective assistance of counsel. And in this case, it will help somewhat. There still could be things that Pryor would do at trial or with evidence that might be. But as to the one issue of whether or not Chad wanted this lawyer with this lawyer's experience to represent him, Chad said he did. So as to that issue, I think it would be covered. I don't think it would cover everything that Pryor did. I think there could still be things Pryor would do that would be considered ineffective assistance of counsel. I mean, it's possible. I have no idea whether he'll actually do any of those things. I'm just saying, as far as appellate review goes, yeah, it's possible that there would be something that could still be looked at and there could still be a claim like that. So thank you, all of you. It's been great having you. Be sure to hit the like button, subscribe. We'd love to have you back for more. We go live Monday, Wednesday, and Friday at 7 p.m. Eastern. So we will look for you to be back here, and I will see you on Wednesday at 7 p.m. Eastern. Prosecution showed it to jury, and so you can get a pretty good look at it too. Red blood-like substance on it. He said it was even wet and leaking everywhere. That was a quote. Zip ties, a razor blade. Why were these items there? And in the back window is a bobblehead of Alec Murdaugh going back and forth.